complex negotiation, of course, have their own separate arbitration agreement. And these entities tomorrow could be outside the group company also. Tomorrow, my lord, these entities could be sold by the Severn Group or the Chloro Group. They are always not separate legal entities entitled to their own rights under their respective agreements.
Let's quickly now go on to point number 3. This is your attack on Chloro now.
Yes. But may I just go directly to point number 5 first and come back?
Point number 5?
Yes, that is at page 6. I'll just deal with Chloro, and now I'm dealing with whether this doctrine can be found in 8 or 45, and then I'll deal with whether it can be found in...
Actually, why don't you read you've done it properly, actually.
Yes.
No? Let's go back to your Roman 3.
Yes.
You've evolved it logically.
Yes, very. But what I've tried to submit in Roman 3 broadly is...
Let's go read.
Yes.
Let's read.
Arbitration is based on consent and party autonomy. But Section 9 of the CPC provides that all civil suits shall be subject to the jurisdiction of courts, except where there is an express or implied bar. As held in Dhulabai versus Madhya Pradesh, jurisdiction of the civil courts is all-embracing, except to the extent it is excluded by an express provision of law or by a clear intendment arising from such law. An ouster of the jurisdiction of a civil court is not to be lightly inferred. I don't need to place that judgment. I've just extracted the relevant principle. Because this is the guiding principle which ousts. Yes. Section 5 of the Arbitration Act contains that bar to the jurisdiction of civil courts. It ousts the jurisdiction of civil courts in matters, Lordship may mark, governed by the Arbitration Act, except where the Arbitration Act so provides. Lord, the submission was, Lord, that Section 5 ousts the jurisdiction of the civil courts in respect of matters governed by the Arbitration Act. Therefore, Lord, to say that there is no inhibition in the Arbitration Act to this doctrine may not be sufficient. It must actually be found in the Arbitration Act, because ultimately it ousts the jurisdiction of civil courts. And how does the Arbitration Act govern it? Is the parties' agreement to arbitrate.
The first sentence is important, para 13.
Yes, the parties' agreement to arbitrate as a condition to the ouster of jurisdiction of a civil court is therefore essential.
Which is section 28 of the...
and section 28 of the Contract Act. Once the clear intention to arbitrate, as expressed in an arbitration agreement, has been identified, then arises the concept of party autonomy, which has been recognized as the cornerstone of arbitration by various decisions of this court. Given party autonomy, parties are free to choose the seat of an arbitration, the number of arbitrators, the procedure for appointment of arbitrators, the rules governing the arbitral procedure, the institution which will administer the arbitration, subject to the disputes being arbitrable under the law applicable. However, party autonomy is premised on the autonomy of a person to choose to arbitrate and with what my Lord the Chief Justice was putting to me. It is in order to ensure that the ouster of national courts is not lightly inferred in favor of a dispute resolution by a private forum, and to give primacy to consent and party autonomy, that the Arbitration Act prescribes the form read, then an implied term is also being read into the contract, into the arbitration agreement at least, for the first instance. Perhaps even in the substantive underlying contract, but certainly in the arbitration agreement. An implied term is being read that some other persons are bound by that arbitration agreement. And that's what I'm going to try to lay down the test in Nabha Power. In Nabha Power versus Punjab State Power Corporation, this Honorable Court has held that courts may imply a term into a contract only if all the following conditions are satisfied. It is reasonable and equitable. It is necessary to give business efficacy to the contract. It goes without saying, and it is capable of clear expression, and it must not contradict any express terms of the contract. But if I may just pause here for a minute and explain this point. Your Lordships have not an arbitration agreement, a typical arbitration agreement, that says any dispute or difference arising under this contract between the parties hereto shall be settled in accordance with the following procedure. And typically it says that party A will nominate, party B will nominate, and the two nominees will appoint a third person. Now, what is happening perhaps by reading in an implied consent is that arbitration agreement is being now subjected to an additional term, an implied term. And to do that, the test would be much higher than just business efficacy. It would be these tests laid out, this Penta test in Nabha Power, which is that an official bystander test, that anyone sitting in the negotiating room, if asked, is this non-signatory a party to the arbitration agreement, would say, but of course. Well, that is how the test has been first put down. That someone would say, but of course, there is no doubt about it, that a parent would also agree, would also have agreed to be bound by the arbitration agreement. And I'm placing it a little high because your Lordships are dealing with a range of situations which this doctrine will apply. But in the context of modern corporations, group companies, group structure, it is hard to conceive how an employee would be able to participate in a negotiation discussion and bind the company itself, absent it being a signatory to it. I place that because, again, Mr. Khambata has taken your Lordships through the provisions of the Companies Act. Ultimately, a company will act through its board of directors. And a significant agreement would have to be authorized duly and signed. It would be very hard to imagine a situation where an employee would be binding his company without actually signing the contract. And that's why I tried to give an example of a arbitration clause in footnote 13, which is an arbitration clause between parties, the end of the second line. It's between the parties in footnote 13. And what is happening is parties are therefore being added. An implied term is being read, and that it's not just parties, but parties and certain group companies. The other aspect which involves a layer of complication is where a group company has signed a separate agreement with its own arbitration clause, then that arbitration clause is being negated, and the arbitration clause in the mother agreement is being given effect to. There are two situations. One is where the group company has not signed any other agreement or arbitration agreement. That may be one class of situations. But the other class is where that particular group company has specifically entered into an agreement with its own arbitration clause, as was there in fluoro control. Now, that arbitration clause is in effect being given a go-by. In effect, that arbitration clause is being given entirely a go-by, and that party is being told that you have actually acceded to or agreed to the arbitration agreement contained in the mother agreement. So, one of the guardrails I would respectfully submit is that even when applying this group company law, where a group company has entered into a separate arbitration, that arbitration agreement, where it has entered into none, perhaps mutual intent could be read to be part of the other arbitration agreement. But when the intent is actually expressed in a written agreement, including a written arbitration agreement, as was the case in Tribunal, that may be difficult to circumvent. Well, I'll read on from paragraph 8. It is ex facie evident that given an arbitration agreement in writing, which addresses itself to disputes between the parties, this penta test is incapable of satisfaction. In effect, under the guise of business efficacy, the arbitration agreement is sought to be rewritten, ignoring the clear terms of the written agreements, which are, especially in multi-party, multiple contract situations, the subject of long and hard negotiations. And again, I wish to draw a distinction between when your lordships have deployed the principle of business efficacy to give full effect to an arbitration agreement from this anterior stage, where your lordships are examining whether there is an arbitration agreement, and if so, among which parties.
No, Mr. Rai, we're talking about business efficacy. What about litigation efficacy? There is another contract, consolidation of the proceedings. That would also require us to apply the principle. I mean, may not be in this fashion.
Yes.
But otherwise also consolidation, if it's relating out of same kind of a, we have to efficacy of the litigation is also a factor we have to take it.
I bow to that observation. There is a challenge. There is a problem. The institutional rules also deal with this problem. They provide for consolidation of disputes where arbitration agreements are consistent with each other. Where, for reasons best known to the parties, they have agreed that a technology license agreement will be governed by the laws of, let's say, Germany, with the seat in Germany, but the trademark license agreement will be governed by another body of laws administered by a different institution. But the institutional rules would not permit consolidation. And my respectful submission, my lord, is that Section 8 is not a provision for consolidation. Respectful submission. Neither is Section 11. And in doing consolidation under Section 8, we may be affecting the institution's ability to run its arbitration as per the arbitration agreement with the parties. My lord, I bow down entirely to what my lord Justice Roy is saying. There has to be, my lord, litigation efficiency. But that is also in large measure something to be determined by the parties when they are negotiating. They may provide for how a particular dispute will be resolved if it involves all the parties to the joint venture agreement and the other subsidiary agreements. But ultimately, my lord, the cornerstone of it may have to be, my lord, the parties' agreement itself. And if they have chosen a unwieldy or unwise, in a sense, process, that is, my lord, what they have chosen. My lord, your lordship put it well, my lord, that there may not be a soft solution to hard negotiations. Ultimately, these are hard negotiations. And, my lord, oftentimes, I may say this, my lord, with experience as being a corporate lawyer in my initial years, there are reasons parties choose particular seats or particular institutions or particular applicable law. And my lord, in certain instances, perhaps the Lord may not be respecting that choice as firmly as it should be. Further, it is a set principle of contractual interpretation that previous negotiations and declarations of subjective intent included from consideration while interpreting the terms of the contract. Section 90 of the Evidence Act states that where the terms of a contract be reduced to writing, no evidence shall be proof of the terms, except itself. In Rukhsar versus Mohan Thedani, the Honorable Court recognized the written contract, liberation on the part of the contracting parties, and it is natural that they should be treated with careful consideration. And that wherever written instruments either by the requirement or by the contract of the party, be the repository, any other evidence is excluded, be used as a substitute for such instruments or to contradict them. When the terms of the contract are clear and ambiguous, only the express terms can be relied on. Therefore, where an arbitration agreement clearly sets out the parties thereto and the arbitral procedure agreed among them, no intention to bind persons other than the named parties can be read into the agreement. Similarly, where the underlying agreement contains an entire agreement clause or a clause providing that amendments to the agreement, if any, can only be made in writing, the arbitration clause cannot be interpreted in a manner so as to expand its reach to parties not named as parties to the arbitration agreement. And I've just footnoted at footnotes 17 and 18, just an illustration of what an entire agreement clause looks like, and what a clause with modifications of the agreement shall be made except in writing. And my respective submission is, Lord, to the extent of the group company doctrine as formulated in Chloro Control Mirror, and I'll come to a narrower or prescribed version of it, Miller. But to the extent this group company doctrine as laid down in Chloro Control, it, Miller, goes against perhaps the written agreement of the parties itself. Miller, as Mr. Lord, one of the tests that he laid down was that it should apply in reverse also. If a party can assert that it is a claimant under the, then it also has to be a defendant. In that context, that I submit that you are therefore telling an opposite party that not just the party you contracted with, someone else can also lay a claim against you. And that, my lord, would be reading an implied term. But again, your lordship, with a myriad setting, there may be standard form of contract where this issue may not arise with its full force. But where, my lord, can be into a written agreement, defining that only they will be subject matter of an arbitration, then parties are an implied term is being added. And further submission was that if that term must be done on the principles of NABA. And again, we're speaking with all humility and some sense of responsibility, but it's hard in commercial contracts how that test can be, how it can not be contended. A parent sitting in the US tended to be bound by the other people without even signing. After my submissions on section 7, come to know whether this can be a principle found in section 8 or 45 of the Arbitration Act. Before addressing whether the group of companies doctrine can be drawn from section 85, the scope or nature of the principle. Sections 8 and 45 are provisions in aid of arbitration. Right, how a judicial authority must act when an action is brought before it, that is the subject matter of an arbitration agreement. The provision is intended to ensure that if an action is brought on a matter that is the subject of a party or any person claiming through or under the party can be parties to be referred for arbitration. This legislative intent is also clear from section 40 and 41 of the Arbitration Act with the words. But section 8 and 45 are not which contemplate or can be read to contemplate the addition of persons as being found by the arbitration agreement. This is my respectful submission. These provisions do not purport to and cannot be relied on to alter the definition of an arbitration agreement as set out in section 7. That the constitution of an arbitral tribunal or the parties to the dispute are matters separate from section 8 is made clear on a reading of section 3. 8.3 makes clear that notwithstanding the pendency of an application under 8.1, an arbitration may be commenced or continued, and even an arbitral award made. Well, may I request your lordships to just read that one provision with me? This has not been placed. Lordships has under section 8.3. Section 8.1, which is the application. Notwithstanding that an application has been made under subsection 1 and that the issue is pending, an arbitration may be commenced or continued, and an arbitral. Now, consider a control kind of situation where without one party under an agreement to which it is a party and that agreement has an arbitration clause. If it commences an arbitration under that agreement, before, for example, the ICC, it was the case in one of the agreements, then that arbitration would continue in just those parties. I hope I make myself clear. Because it is, again, I will endeavor to see how one can resolve the complex situation But this is one complexity of the other nature that arises. The party which has a specific arbitration agreement is being denied the full effect of that arbitration agreement. And this is all done after negotiations between the parties. And this is I'm making the submission based on 8.3. Based on 8.3, that a party can commence its separate arbitration. And I'm partly responding to my Lord Justice Roy's comment that therefore 8 is not a provision for consolidation. So ultimately, consolidation has to flow from consent of the parties or the institutional rules deal. If their agreements are compatible with each other, the institutional rules will not provide for consolidation. But if you have neither consent of parties or compatibility of arbitration agreements, then there may be a certain and litigation in your dispute resolution. Separate from, I'm now on Roman 6 of my submissions. Separate from an understanding of the scope of Section 8, that it cannot and ought
It's more or less the same. Yeah. 5 and 6 are more or less the same.
Yes. But 5 and 6, 6, I was trying to explain that of claiming through and under. Let us read that. As stated in Section 2 of these submissions, the court in chloro controls relied on the words claiming through or under appearing in Section 45, subsequently also inserted in Section 8, to conclude that Section 45 contemplates reference of non-signatories to arbitration. As stated above, the court in chloro controls recognize the category of persons who would be persons claiming through or under. These are persons who claim in the same capacity as the parties under or through which they claim, such as assignee or successor in interest. As held in Sharon Properties, the expression claiming through and under directs attention to the source of the right and is a legislative recognition of the doctrine that an arbitral award binds every person whose capacity or position is derived from and is the same as the party in the proceedings. There's a similar reasoning in 20, which is the Australian research. But your lordships in paragraph 20, Sharon, laid out what it is mean to mean acting through or under. The cause of action such is derived from a party to the other. They do not claim an independent right based on the implied consent to the contract. However, in chloro controls, the persons sought to be brought within the ambit of arbitration were separate corporate persons who claimed independent rights under separate agreements. These persons were not claiming through or under the party, but rather claiming independently in their own right. Therefore, the doctrine of parties as articulated in chloro controls cannot be traced from the phrase claiming through or under. At the highest, it may be contended that parties to an ancillary agreement have incorporated by reference the arbitration agreement contained in the parent agreement on the basis that the parent agreement references the ancillary agreement or annexes a form of that ancillary agreement to the parent agreement. This is also part of the reasoning in chloro. However, the arbitration agreement contained in the parent agreement can be incorporated into the ancillary agreement only to the extent that the ancillary agreement does not itself contain a separate arbitration agreement. Therefore, to the extent this was done in chloro controls, despite a separate, distinct, and different dispute resolution clause in a particular ancillary agreement, I just want to respectfully submit that even that aspect of the decision is required to be. Well, therefore, these are my submissions, first on Section 7, then on Section 5. But I'll rush through this next section, which is that in earlier decisions, your lordships have articulated what it means to have an arbitration. And it's my respectful submission that that hasn't dealt with those decisions fully. Paragraph 13. We submitted that chloro controls is required to be overruled also because it did not adequately consider or contend with the previous decisions of this court on the subject. But in Wellington Associates versus Kirit Mehta, the court held that Section 7 of the Arbitration Act required the agreement must necessarily or mandatorily require the appointment of an arbitrator. Jagdish Chandra Miller, I may just come to the italicized portion. the intention of the parties to enter into an arbitration agreement shall have gathered from the terms of the agreement. And that if the terms of the agreement clearly indicate an intention on the part of the parties to the agreement to refer their disputes to a private tribunal for adjudication, and a willingness to be bound by the nature of such tribunal and such disputes, it is an arbitration agreement. And I'm placing emphasis on the fact that that to enter into an arbitration agreement, that intention has to be gathered from the terms of the agreement, not implied. It has to be gathered from the terms of the agreement. And the court further held that while there is no specific form of an arbitration agreement, the words used should disclose a determination and obligation to go to arbitration and not merely contemplate the possibility of going for arbitration. Then, Your Lordship, paragraph 34 was Sukanya. The court will distinguish Sukanya on the basis that at that time, Section 8 did not provide for persons claiming through or under. But my lord, at the end of paragraph 35, therefore, I make submission in the last 5 lines. It underscores that the court in chloro control relied entirely on the language of Section 45 of the Arbitration Act to justify the group of companies doctrine without considering whether such input is consistent with the definition of an arbitration agreement in Section 7. But there was a similar issue that arose in Indo-Wind, and this was not in that case. The court also did not refer to or consider the wherein an arbitration agreement entered into by 2 companies was sought to be extended to a 3rd company. Indo-Wind, on the grounds that Subhuti was a promoter of Indo-Wind and that the person who had signed the agreement on behalf of Subhuti was also a director of Indo-Wind. The court rejected these conditions, stating that if the director who signed on behalf of Subhuti was also a director of Indo-Wind, and if the intention of the parties that Indo-Wind should be bound by the agreement, nothing prevented Westcare insisting that Indo-Wind should be made a party to the agreement and requesting that the director who signed for Subhuti also to sign on behalf of Indo-Wind. This is, in some senses, the heart of the case. That there is nothing that prevents parties from insisting that that non-signatory sign the agreement at the relevant time. The court also dismissed the attempt to draw an inference that Indo-Wind party to the arbitration agreement from the conduct of the parties, holding that while an ordinary contract may be entered into oral or spelled out from correspondence, the same cannot be said. The court held that if Section 7 says that an arbitration agreement should be writing, it will not be sufficient for the petitioner in an application under Section 11 to show that there existed an oral agreement or that Indo-Wind had transacted with Westcare or Westcare had performed certain acts with reference to Indo-Wind as proof of an arbitration agreement. And I just want to spend a little time on this aspect, on performance. Again, performance must be performance of a corporate entity as a corporate entity. It can't be without my submission that just by an employee writing a letter or an email saying that I understand that the services agreement with SAP India has some difficulties, we are working to iron out those difficulties. That contract then is taken over by SAP. But therefore, performance.
It said that we'll take care of the issue.
Yes.
Something to that effect.
Yes.
So when you say take care, what would it mean? That the subsidiary in India is not able to take care and will take care? Well, of course, you have said that it may not be a letter written by the company itself, but one of the person on the company.
Yes.
But then the person to whom the promise was made or the assurance was given, they would go by that understanding that the principal has said that we'll take care of the issue.
Facts, Your Lordship, are not going into that fully. Of course, the email originated from Cox and Kings. What that correspondence can mean, in my respectful submission, at the highest, is that we will look into how SAP India is executing this contract. Kindly similar, by that email, SAP Germany is not going to start receiving consideration for the contract. For the consideration that is flowing. Therefore, the entire performance is still by SAP India. Qua Cox and Kings, Cox has no relationship with SAP Germany. I mean, I dare say they have no contract.
That's right.
But they actually will not have no legal relationship, although that's a matter separate. That is a separate matter from the arbitration agreement. But what is being done in instances like that is really someone senior in the organization is saying that we will talk to our colleagues in SAP India and they will execute the contract. I hope I make myself clear.
No, I mean, we may not exactly go into the facts here
Yes.
and precise correspondence, but suppose the correspondence is such an issue which is arising between A and B, and C, which is the German parent company, C says that we'll take care of it.
Yes. Again, that is an email authored by a particular employee.
No, I mean, let's not go into precise the facts.
I appreciate it. But the submission I leave it at that. What we talking then of an assignment of the contract or even an ovation. And if that is what we are doing, then is that consistent with the terms of the contract itself? And it will not be consistent. That's why these issues would get a life of their own, in the sense that if this goes into an arbitration, your Lordship is aware, we can't challenge the Section 16 dismissal. If Section 16 is filed before the arbitral tribunal and comes to be dismissed, then you have to participate in the arbitration through its entire journey. And you can challenge it in Section 34. And that's where, in some sense, the stakes are high. To not involve a party that is not a party to the arbitration agreement. And juxtapose with how do modern corporations transact? They transact through written contracts.
No, that threshold has to be very high.
Yes.
First and foremost.
The US and Germany are providing services in India.
I mean, suppose the facts are such that yes, it could be understood as an ovation of the contract. Believe or do.
Well, the entire team working on it would still be SAP India. I'm only saying
No, that of course.
that may not be what the person also understands. We're escalating the issue. But the person with whom we are is still always SAP India. We're escalating the issue. Someone will look into it, but the understanding may not be that simple that by just a letter, you making it to SAP Germany.
In golfing terms, if you use a rescue
Yes.
to get out of this tricky situation, the German company is saying, I'll rescue. What happens?
I would only say the German company is the caddy who hands you the rescue.
Okay.
But you have to still hit the rescue. And I'm only submitting this in the context of this issue will affect modern corporations. And if they were to make party to an arbitration agreement, which is a seat not chosen, procedure not chosen, that may have some consequences, separate from the fact of what this relation they have entered into with Fox and in this case. But if SAP Germany is faced with the situation, this case now not just that there's an arbitration agreement, but there is a contract or a claim against SAP Germany. And those are two separate issues, arbitration agreement and legal relationship. But the line is very clear. But ultimately, these parties are being made parties to the arbitration agreement to be made part of the main contract also. Ultimately, those are the claims that are being made. And I'm only respectfully submitting that would be done by a formal arbitration, in which case they would anyway be parties under the agreement, as paragraph 70 of the protocol. Where it is just a claim, it can't rise in my respectful submission to the threshold of innovation or an assignment of the contract. So I'll just place 38 because MR Engineers has a nice formulation of appropriate guardrails perhaps. Para 38. Reference was made in chloro controls to Section 7.5 of the Arbitration Act and decisions of this court to incorporation by reference. However, the conditions subject to which a clause contained in one may be deemed to be incorporated in another. In MR Engineers versus Somnath Builders, the court held that Section 7.5 requires conscious acceptance of the arbitration clause contained in other document, and a general reference to the other document is not enough. The court also held that the court would have to examine whether the intention of the parties was to incorporate the entire agreement or only a specific portion thereof. The court summarized the principles relating to incorporation as follows. General reference to a document containing an arbitration clause is not enough. A clear reference to the document containing the arbitration clause is necessary. The reference should indicate intention to incorporate the arbitration clause. Where a contract provides that its execution or performance shall be in terms of another contract, which contract also contains a provision for settlement of disputes by arbitration, the terms of the referred contract relating to execution performance alone would apply, and not the arbitration agreement contained therein, unless there is a specific reference to the arbitration clause. This requirement may not apply where the contract provides the standard form of terms and conditions of an independent trade or professional institution to bind the parties, and such standard terms containing arbitration clause. And 5, the arbitration clause sought to be incorporated should be capable of application to dispute sought to be incorporated. This decision further supports the conclusion that this court has always required the parties to a firm undertaking of agreement to arbitrate, absent which an arbitration agreement will not be inferred. And then, my lord, chloro control I've dealt with, my lord, 158 use this expression of incorporated by reference. In the face of a contradictory dispute resolution clause, that my lord, reference may not be missed. And finally, my lord, paragraph 41. The court to refer a non
Let's go with this.
So how long now, Mr.
Lord, 15 or 20 minutes. I'm conscious of my time. Lord, I'll just rush through some of these points.
You address us more on 7. 7
Yeah.
is a crucial part of it because
Yes.
everybody is focused on 7.
Yes, Lord, may I just go through this itself and I'll just complete in 15
Yes,
minutes.
yes.
Roman 8, Lord, of my written submissions
Yeah, that's right.
makes the point about the Law Commission recommendation.
That's right.
Right.
And Lord, at paragraph 45, I also narrate which other provisions of the Arbitration Act party, which would all be impacted by this particular. Lord, I've already made briefly my submissions on the 4 cases, Lord, that are also concerned here, Lord, which followed chloro control. I'll just place on Cheran properties, Lord. If I may just read my discussion or my understanding of Cheran properties.
Yes.
In this case, the court was considering a share purchase agreement which recognized the right of KCP to sell or transfer his holding in SPIL. This is important, provided the proposed transferees accepted the terms and conditions mentioned in this agreement. Similarly, the agreement itself contemplated a proposed transferee accepting the terms and conditions of the agreement. And it is pursuant to this share purchase agreement that KCP addressed a letter acting as the authorized signatory of Cheran and making a clear and categoric reference to the share purchase agreement, and that's paragraph 32. In that context, and examining section 35 of the Arbitration Act, which makes an arbitral award final and binding on the parties and persons claiming under them respectively, this court rightly, Cheran, the nominee of case, bound by the award, even if it was not a party. The decision, insofar as it refers to and relies on chloro, does so to negate the submission of the appellate, that is Cheran, that the group of companies doctrine cannot be applied in this case. It is in that context now that the court was asked to go into the group company doctrine. However, what is applied after the discussion of paragraphs 23 to 28 by the court, they was the group of companies in the phrase claiming, because in this case, Cheran property could only claim its right to the shares through KCP, who had suffered an award. So this is
So we held that Cheran is really bound by the award which was rendered against KCP.
Yes.
Though Cheran was not a party to the arbitration proceeding. Because Cheran had the KCP, KCP had assumed a right to transfer its shareholding, provided the transferee agreed to be bound by the same terms and conditions. And Cheran had expressly stated that it was bound.
Yes. Yes.
And therefore, it had assumed, because it had assumed those contractual obligations,
yes,
then the award also bound it. That's what we said.
Yes, I'm grateful. But I'm grateful. That's how I've understood that decision. And really, red herring of chloro control was raised, but actually it was a case of taking under, because it was a signing off. But Amit Lachan has now adopted just the second part of that chloro control test. And merely because agreements are interlinked, parties have become bound by the arbitration agreement. And in this case, it was an unrelated party also. And therefore, I've submitted with respect that that decision may not be correct because I extended it purely on the fact that there are interlinked contracts. And I just read from line 8 or 9, the issue that may arise. Line 9 or 10, this may best be illustrated with a simple example of a principal employer who engages a contractor pursuant to principal agreement. That contractor in turn engages one or more subcontractors under one or more separate subcontract agreements. Assuming the agreements contain separate arbitration clause, the mere fact that both sets of agreements relate to the same commercial project cannot be the basis to conclude that the subcontractors have agreed to be bound by the arbitration agreement contained in the principal agreement. To do so would defeat the expressed intent of the parties to be bound by that particular arbitration agreement entered into among them. And in the case of arbitration agreements that contemplate institutional arbitration, this would also impact relevant institutional rules of consolidation of arbitration. It would also have the effect of converting what would otherwise be a purely domestic arbitration into an international commercial arbitration, which in turn would determine whether the ground of patent illegality would be available to the parties to challenge the award. The submission here is when parties are, as in my case, SAP India and Fox and Keynes, then it's not a domestic arbitration. Now, if you bring in a non-Indian party, to use the term, then you convert the character of that arbitration also. And that's where I come from when I submit that agreement has to be read a little carefully. But MTNL, Canfina was not a party to the agreement to arbitrate, and therefore I submit that decision may not have been made by to be overruled. ONGC versus Discovery. Again, facts will be clear. In this case, ONGC had entered into a contract with the Discovery Enterprises Private Limited, but brought an arbitral claim against EPL and a sister company, Jindal. ONGC also filed an application for discovery and information to make its case that there existed functional, financial, and economic unity between DEPL and JDIL. Without considering this application, the tribunal allowed JDIL for deletion. It was this section 16 set aside by the discovery application should have been decided first, especially as JDIL failed to produce. Tribunal's order was prior to this. The tribunal didn't have the benefit of fluoro control because it happened much later. Inasmuch as this was the basis for the decision of this, documents produced by DEPL may have made out ONGC's alter ego. And since the case was remanded on the basis the tribunal did not have the benefit of this court's decision in fluoro control, the decision may not require reconsideration. Well, just very quickly, fluoro control erroneously states that English law supports the group of companies doctrine. There's no international consensus on the applicability and extent of the doctrine. But I've reproduced the definition of party from the English Arbitration Act. I've reproduced that definition, and your Lordship sees, my Lord, references in this part to a party to an arbitration agreement include any person claiming through or claiming under or through a party to the agreement. And despite this, my Lord, English law doesn't apply the group of companies doctrine. Importantly, my Lord, Singapore, since it's such a poor arbitration, also, my Lord, rejects forced jointers. The words used in that judgment are that it's a drastic. Similarly, the United States. Para 50 and 51, my Lord, I've again just set out Dow Chemicals and explained that arbitral awards do not create a precedent, and also rendered under different laws that are not. Lord, paragraph 11 of my submissions, again, I won't spend too much time on, my Lord, but I'll just read out the heading. The submission of the group of companies can be discarded only if the Arbitration Act expressly prohibits it.
That was Dr. Singhvi's sir.
Just read that by saying, my Lord, that section 5 says, as governed by this, and therefore, my Lord, it must be found in section 7, 8, or 45. My Lord,
go to para 12, I think that's your wrap up.
Yes, para 12. Rejecting the group of company doctrine advances arbitral practice and provides clarity. The following principles emerge from the discussion in the preceding sections. Arbitration requires consent as to the party's intention to arbitrate. This consent is provided by requiring an arbitration agreement be in writing. The intention of the parties must be gathered from the words used in the contract, and where those words are unambiguous, their plain meaning ought to be given effect to. Where the parties have incorporated into the underlying contract an entire agreement clause, the parties' previous negotiations cannot be relied on to discern whether the parties had an intention to bind any third party to the arbitration agreement. Of course, where there is a principal agreement and ancillary agreements arising therefrom, the arbitration clause contained in the principal agreement may be incorporated by reference into the ancillary agreements, provided that the ancillary agreements do not contain any inconsistent dispute resolution clause. However, this does not require the invocation of the group companies doctrine. In such a case, reliance would be placed on section 7, 5, and the law laid down in MR Engineers. Under Indian company law, an agreement entered into by one of the companies in a group cannot be binding on the other members of the same group, as each company is a separate legal entity which has separate legal rights and liabilities. I rely on Vodafone. Mr. Kambata has already argued. Therefore, my conclusion, the group of companies doctrine is inconsistent with these principles and with the principle of party autonomy. It is submitted to the doctrine, far from advancing arbitral practice, in fact, detracts from it. This is because it introduces a significant element of uncertainty and discretion in determining the persons bound by an arbitration agreement. Consequences of this uncertainty are significant. If a person asserts that it is not a party to the arbitration agreement, that person will have first to have recourse to section 16, and if unsuccessful, will have to participate in the arbitration proceedings before challenging an award under section 4. If it is then determined that it had not impliedly consented to the arbitration agreement, the award would have to be set aside and parties relegated to the civil court for adjudication of their disputes. There may be no easy answers in disputes that arise in the context of multiple parties or multiple agreements. That is why institutional rules also have separate rules for consolidation of disputes or jointer of parties. Ultimately, though, the answer ought only come from the terms of the arbitration agreements entered into between parties. If the parties have entered into distinct separate arbitration agreements, or as in the case of chloro control, dispute resolution clauses that contemplate adjudication by a civil court, or if there are persons who are not party to any arbitration agreement at all, there is no basis to consolidate all the disputes applying in the company's doctrine. It's therefore respectfully submitted that the doctrine ought to be held, if not valid, in Indian law. Well, I will just add one footnote. If your lordships consider the guardrails or prescribing or limiting the doctrine, my respectful submission would be that the second limb of chloro control, which says that when there is a commonality of the agreement, even absent this non-signatory consenting, principle can be employed. That part, my lord, may be too broad.
Right.
The first part of the chloro control test, my lord,
The mutual intent part.
mutual intent, my lord, can be read in only in those cases where the group company is itself named in the contract as a party and actually performs the contract as a corporate entity.
Right.
The Dow Chemical kind of situation. So, my lord,
Thank you so much, Mr.
Lord, I also appear in the matter that Dr. Singh appeared. Lord, I also appear on the other side. And that's just one sentence on that. Lord, that arose from a deed of family settlement, which was between certain individuals of my lord, the Kirloskar family. Dr. Singh's client, my lord, filed a suit arraying all the individuals and also various listed and unlisted companies of the Kirloskar group. So, in fact, my lord, they filed a suit recognizing perhaps that the group of companies doctrine would not capture this. They actually filed a suit. As it transpired, my lord, the companies whom I represent said, without prejudice to their argument that they are not parties to the family settlement, the contract, they are agreeable to go to arbitration. That is what, my lord, we gave in the Bombay High Court. So actually, my lord, that case doesn't really arise here because, in fact, they've taken opposite position.
That's wonderful. Right, we'll wrap up at this point and we'll take up now.
One last statement,
Yes.
Oscar Miller. As I said, Miller, that issue is the issue that Mr. Kambata addressed, whether individuals can bind listed companies. It doesn't really arise in this case. I just want to place that.
We'll start tomorrow with Mr. Diwan. Liz, you want to also argue? All right. You are instructing Mr. All right. So now the only submission left on this side is Mr. Diwan. George, you want to argue?
Intervention on national committee on that.
Oh, you are appearing for the Unsitral National Committee. So you will guide us dispassionately. You be like a really and a Michael's Curie.
Yeah, just 10 to 15 minutes.
And Manoj, there's Mr. Sanjay Ghosh who says he'll take about 10 minutes. He was here in the afternoon.
No difficulty. Mr. George, you can give us whatever material you have, you know.
Yeah.
You have filed that.
I'll-
All right. You have circulated because Unsitral will have a lot of underlying material.
Yeah, I mean, just about the
we
model
should be
law
happy
and
to see that.
relation with the New York Convention.
All right. So about half an hour for you tomorrow. Say about 11 o'clock to 11:30.
For me,
Yes. Now I think we have heard substantial arguments.
I had in fact anticipated about an hour and a half. Your lordships had told me that your lordships would give me.
Now I think we'll wrap it up early because we have a special bench. We don't want to spill it over because next week we have another constitution starting on.
Much of you can just indicate to us.
Okay, we have to close now.
I'll certainly will try because I kept on cutting my cloth based on what was said.
If you have a good night's rest, I'm sure you can
No, I
Consolidate further.
certainly will. If your lordship thinks I'm, I mean, I certainly don't intend to repeat anything that.
If you are tired like we are when we start dictating judgments, it will be very long.
Correct. But, so there are a couple of other facets which, in fact,
If you're fresh, that's what my brother says, then it will be brief and.
no, I certainly will. I mean, I don't think your lordships have ever seen me.
So half an hour and then George, 15 minutes for you.
Because can I just, because I'm certain I won't be done in half an hour. There are certain aspects of the.
20 minutes?
If your lordship is cutting.
Raman Shyam.
No, your lordships may give me at least an hour and a half. Minutes.
At least an hour.
I'm so grateful.
रितु, मुझे तुम्हें किस करना है? हेलो।
रितु है ना, मेरी बंदी है। रितु से दूर रह।
कहाँ रहती? लड़ाई के नाम पर गुटर को चालू है।
यार कर्फ्यू लगा दिया उस बेचारे ने। 24 घंटे नजर रखती है उसकी माँ। हमारा शो गुटर को देखिए Amazon मिनी टीवी पे।
वो भी बिल्कुल फ्री में। बस जाइए Amazon शॉपिंग ऐप पे और क्लिक कीजिए मेरी टीवी का आइकन।
Justice Chandrachud, I want to start by asking you straight up about the challenges India's judiciary faces. At this moment, if you look at the number of pending cases in this country, there are about 4.32 crore total pending cases. 69,000 of them in the Supreme Court, a backlog of about 59 lakh across 25 high courts. Could you start by telling us, all of those who are watching you here at the India Today Conclave, watching live on TV and on social media, about your broad vision to transform, modernize India's judiciary? Let's start from there. Justice Chandrachud.
Well, it's true that we have a large backlog of cases, but another way of looking at it is, I think it's reflective of the faith of the people in coming to court in the first place, which is not to justify the backlog. We should be discharging the faith of the people by being more efficient and by reducing the backlog. But that's just an indicator of the kind of faith people have. It also shows that there is a dearth of adequate infrastructure in the judiciary. Our judge-to-population ratio is not commensurate with what it should be in a country like ours. That's another problem. The third problem, of course, is the lack of infrastructure in the district judiciary. But now coming to your question about my vision, I think what we need to do is completely modernize the Indian judiciary. Our model for judicial administration has been based on the colonial model which we inherited from the British, which is that people have to access justice. It's also reflected in the design of our buildings, these grand colonial buildings, which were intended to sort of create a sense of fear and awe about the court in the minds of people. And I think that colonial model now has to give way, because justice, to my mind, is not just a sovereign function, which it is, but justice is also an essential service which we provide to our citizens. And part of my mission of dealing with where we should be in the next 50 or 75 years is to transform the Indian judiciary with the use of technology. We saw that in the COVID-19 pandemic. The COVID-19 pandemic was unanticipated, possibly unexpected as well. We couldn't have shut down the doors of courts. We had to keep our courts open because you have to answer the need of citizens who seek bail, their personal liberties are at stake, their lives are at stake, their careers are at stake. So we launched a whole system of video conferencing. And if you'd like me to share the data which I have with me, the kind of work which we did on the video conferencing platform in the pandemic is unprecedented in any part of the world. So my vision now is that now that hopefully COVID is behind us or almost behind us, as we would like to, because we all lived in a sense of optimism, we now need to look at technology beyond COVID. And we need to modernize the Indian judiciary. We've already taken a large number of initiatives towards having a more transparent, a more open judiciary. We are live streaming the proceedings in at least some of the most important constitution bench cases. Opening up the court's processes to citizens by live streaming them is part of my mission because it enables citizens to understand what goes on in the court. Many citizens would actually turn up feeling that so much of the work which is done in the court is so very boring. But there is a great message which we would like to send to our citizens because the smallest case which comes to us commands the same degree of attention as maybe some of the seminal constitutional cases which we do.
How's the experience with live streaming been so far? One of the things we saw in Parliament with our netas is that the moment the cameras are on, the grandstanding goes up. Are you concerned, Chief Justice, that as more and more cases are live streamed, you'll start seeing lawyers being more filmy and more theatrical in their arguments before you?
Well, in a lighter vein, you always have some professionals who would be given to grandstanding, right? Whether you have a camera in front of them or otherwise, it's not going to make a difference. But I have a sense of optimism. At least my experience thus far, all technology has the good part and the flip side. So likewise, live streaming also has the more difficult part of it. For instance, I'll give you the flip side as well. Very often we are dealing with very sensitive cases involving, say, marital privacy or gender assault or sexual violence against minors. Should you have live streaming in such cases? Obviously not. But therefore, we have the ability to now enable the judge in charge to stop live streaming where you feel that the sensitivities of the case far outweigh the public interest in a transparent court proceeding. Some lawyers would grandstand, some private litigants, some litigants in person may do that. But then we must always look at the benefits as well to be gained when you make it in a holistic perspective.